Good morning, this is your Kelso Report for Friday, August 10th, and I'm your host, Clark Kelso. We begin with an environmental law decision from the Ninth Circuit in native village of Kivalina versus the EPA. The EPA had approved a permit authorizing a company to discharge wastewater caused by the operation of the company's mine. The petitioners challenged the permit in a filing with the EPA, but the EPA's Environmental Appeals Board denied review, concluding that the petitioners had not satisfied the procedural requirements to obtain review under Title 40 Code of Federal Regulations, Section 124.19a, because they had not demonstrated in their petition why the EPA's responses to comments were clearly erroneous or otherwise warranted review. The Ninth Circuit unanimously agreed with the EPA Appeals Board because the petition for review merely reiterated comments that had previously been filed with the EPA, without engaging in any analysis of why the EPA's prior responses to those comments were clearly erroneous or otherwise inadequate. In short, you can't maintain a challenge to a wastewater discharge permit by simply relying upon comments previously submitted as part of the notice and comment period. To maintain an appeal, you need to challenge the EPA's responses and final decision as well. Next, an interesting criminal law case involving homemade machine guns, of all things. The defendant in United States v. Henry was convicted for illegal possession of a homemade machine gun, which is a violation of Title 18 U.S.C. Section 922.0. He challenged the conviction, first claiming that he has a Second Amendment right to possess a homemade machine gun in his home, and second, arguing that Section 922.0 is beyond Congress's Commerce Clause powers. The Ninth Circuit rejected the Second Amendment argument because machine guns are dangerous and unusual weapons that are unprotected by the Second Amendment under the standards set in the Supreme Court's decision in District of Columbia v. Heller. As for the Commerce Clause, the panel relied upon prior Ninth Circuit precedent holding that the Commerce Clause authorizes Section 922.0's machine gun possession ban as part of a broader scheme of federal regulation regarding commerce in firearms. Next, a death penalty decision from the Supreme Court of California. The defendant in People v. Valdez was convicted of 5 counts of first-degree murder, and as to each count found true special circumstance allegations of multiple murder. The jury returned a verdict of death as to each of the victims, and it took a unanimous Supreme Court 127 pages to affirm the conviction and sentence. Next, an insurance law case. In State of California v. Continental Insurance, the California Supreme Court resolved several complex questions of insurance policy coverage in connection with a federal court-ordered cleanup of the state's Stringfellow acid pits waste site. Adopting the continuous injury trigger of coverage rule and the all sums rule, the court held that all of the policies at issue obligated the insurers to pay all sums for property damage attributable to the Stringfellow site, up to their policy limits if applicable, as long as some of the continuous property damage occurred while each policy was on the loss. In addition, the court held that the state could stack coverage to maximize its insurance coverage. As the court explained, these results ensure that insurance coverage extends to the entirety of the ensuing damage or injury, and best reflects the insurer's indemnity obligation under the policies, the insured's expectations, and the true character of the damages that flow from a continuous, long-tail injury, such as groundwater contamination from a toxic dump over a multi-decade period of time. A big win for the state of California. Next, a land use decision. The landowners in Ideal Boat and Camper Storage versus County of Alameda, they own a boat and camper storage operation in rural eastern Alameda County. Beginning in 1964, the county and its Board of Supervisors, through a variety of land use decisions, have approved the use of the property for boat and recreational storage purposes. Then, in 2010, the county denied the landowner's application for site development review to expand its storage facility on the rear half of the property to accommodate up to 720 additional vehicles and boats. The landowners unsuccessfully pursued a writ of mandate in the Superior Court and declaratory and injunctive relief to overturn the denial. Well, the First District Court of Appeal agreed with the Superior Court, finding no basis at all for overturning the county's decision. So, while the landowners can continue the existing operation, which constitutes a legal but non-conforming use, it cannot expand the use as proposed, since that expansion now would conflict with the East County Area Plan, as modified by a voter initiative, as well as the South Livermore Valley Area Plan, which is incorporated into the East County Plan. In other words, the county can change its plans, and when you then have a major expansion, say no to the major expansion. That's it for today's Kelso Report. Have a great day in the law.